This case is a tragedy. We told you from the very beginning that you would see things and you would hear things that would break your hearts. They've broken our hearts too. Miss Alexandra Sabert's death is a tragedy. There's no doubt about that. And throughout this trial, you have seen what the pain of that loss has meant. You saw it when her boyfriend came up here and testified. It was hard. We felt those emotions and we saw all of that. But the law requires you to set those emotions aside and to look at the evidence. The law that you took an oath to requires you to look at the evidence and see if the state has proven their case beyond a reasonable doubt. The judge read to you that you are instructed to not let bias, prejudice, or sympathy play any part in your deliberations, no matter how hard that is for us as humans. That is the law. In this courtroom it is. And the reason being is because the state has the burden today. They have the burden to prove beyond a reasonable doubt that Alex was reckless and that he recklessly caused the death of Miss Sabert. And they have not met that burden. Because what reckless means is that you are aware of those circumstances and you consciously disregard them. You know it's in front of you and you let it go. You keep driving. Go. You know that you keep driving, even though that means you're about to commit suicide or you're about to seriously injure yourself, like we heard the detective say. Those are the only two options. That's what the state wants you to believe, that Alex was aware. And the state hasn't proven that Alex was aware that there were actually cars stopped in the road. The evidence has not shown that. Now, the question is, should Alex have been aware? And all their evidence points to is that Alex should have been aware. He ought to have been aware that there were cars up ahead. But there has been no evidence to establish that he actually knew what was going on. Gary, I want to briefly mention him. Gary has been here throughout this trial. He's been with us, with Alex, and he unfortunately had to go out of the country. He wanted to be here, and he wanted to finish this case last week, as we hoped it would, but we could not finish last week. Now, even though Gary isn't here at one of the most important parts of Alex's trial, we ask you not to hold that against him, because I'm here and I've been here with him and with you all throughout this trial. And I want to get into some of the things that Gary would have said if he were here. This case, when the state opened and talked about this case on Wednesday, they presented to you a case that just involved Alex crashing into Miss Sabert's car. They presented something that was straightforward and easy, that there were no issues at all. This case is not a case where he was driving wrong way on 281 and did a head-on collision. Because then, of course, he would have been aware of the cars coming in front of him. Of course. This case isn't where he's driving 91 miles per hour in a residential neighborhood and Miss Sabert's car is at a stop sign. Because then, of course, that's reckless. That's not what this case is. And I wouldn't be here before you guys today if that's what this case was about. This case is about the perfect storm. Whether we like it or not, that's what this case is about. The dominoes that Gary showed you from the beginning, the series of events that led up to this, the parts that all the different characters played for this to happen. But for Shayna Lassell driving the wrong way on 281, this accident wouldn't have occurred. But for her doing a head-on collision on 281 and causing cars to back up for miles, this accident wouldn't have occurred. And this isn't to throw the blame on someone else. We absolutely know that Alex is in some part responsible for this. This is not to distract you guys. This is not to confuse you guys. This is the facts. If Shayna Lassell didn't cause that accident, And if the officers would have done their job, then this wouldn't have happened. We know that Shayna Lassell, she was never charged for anything. We heard that she was given a ticket after she caused this and then taken to her husband. That's it. That's all we heard. She was going the wrong way on 281. She was, not Alex. And even though he was going 91 miles per hour, he was going the right way on a highway. We know that San Antonio Police Department arrived at 1:56 for the first accident. Second accident happened around 2:20 or so in the morning. That's 24 minutes. 24 minutes that we heard from Officer Morgan, who is an honest officer. He's a good guy. We know he was doing his best out there. We're not here to say he's completely to blame for this. Of course not. But should something have been done to warn people of this huge accident? Of course it should have. He himself told us that something should have been done to warn of the crash to approaching vehicles, because this provides notice to other drivers. There is a reason that the police department has a policy on what to do when accidents occur. It's because things like this have happened before. It's because they know that appropriate policies and procedures need to take place to warn drivers of what's going on, to avoid this from becoming anything larger. There were no flares at all. Now you'll see on the body cam and Coban, that's in evidence, later on after the fact, after this accident has occurred, that they do implement flares and they close down the highway, as they should have from the beginning. They did not reposition their vehicles. There was no reflective vest on, and there was no road closure. We do know that they had their lights on, but there was also a large buildup of traffic after those police vehicles. Cars and cars and cars, it went on. Going back to the crash report, which you have in front of you, and you will have it in evidence, we know that the responsibilities of the officer is to provide warning of the crash to approaching vehicles. They have to do that. They have to warn us. That is their job in the community. If there is a wrong way driver, if there is this sort of accident and it's at night and it's hard to see, you need to warn other drivers. They need to use flares. That's what their policy says. Call in fire units. Request additional officers for traffic or crowd control. Officer Morgan was busy with the first accident. You see it on body cam. He's writing the report when this happens. But he could have requested other officers. And he said that to us. He could have. But he didn't. He did not do any of that. And what does that mean? That means that Alex was not aware of the accident that was in front of him. He was not. We also heard some statements from Officer Morgan. Now, when you see the body cam again, you'll see Alex get out of the car, and he says he's okay. He's confused. He doesn't know what just happened. We've heard testimony. He was airborne. His truck flipped. He was in a serious collision. And that's not to victimize him, not at all. That's just to show the state that he was in when he got out of that truck. He did not know what happened. He was not aware of what he hit. He said he thought he hit an 18-wheeler. He never even knew about Miss Saber's car. Did not know about her. And we never heard from evidence at what point in time did he actually learn about her or her condition. All he knew was that there was an accident, it was serious, and he knew that he had to stay there. He cooperated the entire time. We didn't hear one piece of evidence that he didn't want to cooperate, that he didn't answer questions with the police. He did all of that. He did everything. He stayed for hours and hours and hours. He did not go to the hospital. He did not go to EMS. He stayed there, answered questions, cooperated. Because as you will hear, he said, I just want to know what happened. I want to know what happened. And later on, at some point, he does say that he believes that the Honda came under him. And he believes that the Honda was driving erratically. Now, we've heard testimony that there were cars going the wrong way. Now, Miss Saber, she didn't do anything wrong. We know that. She did not. She was just there. But what other cars were going the wrong way? We've heard from multiple witnesses that it was chaotic. We don't know what Alex saw right before then. We don't know if it was the wrong way drivers coming at him. We just don't know. He doesn't know because he suffered from that collision.
10 minutes in.
Speed limit. Now, the state has the burden to prove that Alex was reckless, and they have 7 different manners and means in front of you. The first being that speed limit. He was not going the prudent and reasonable speed limit that he should have. That alone is not enough. They have to prove that he knew what the speed limit was and that he recklessly disregarded it anyways. It's not just enough to say he was going 91 miles per hour. That's it, case closed. He shouldn't have done that. That's not the way the law works. They have to prove that he knew that it was a speed limit and he disregarded it anyways. What the evidence really shows us, what the photo that Miss Saber took that night, is that right along before the accident even took place, there is a work zone sign that says 45 miles per hour. We know that the accident took place before this. We know that the accident took place after this sign here. That's what the evidence in front of you will show. Right here. That's the only evidence at this table that the state, who has the burden, has provided you. That the accident right after it happened was 45 miles per hour. The issue with that is we have not heard any testimony of what the speed limit was before then. We don't know. Was it 60? Was it 70? Was it 65? Was it 75? No evidence. They want you to believe that he wasn't going the speed limit at 45 miles per hour. That was not the speed limit where the accident happened. And that's an unanswered question. That's an unanswered question that they haven't provided you. They've had multiple detectives testify, and none of them said half a mile before this accident, the speed limit was listed as this. 1 mile before the accident, the speed limit was listed as this. Nothing. Nothing at all. They just want you to look at that and say, okay, he's going double over the speed limit. That's it. That's not the case here. And if you have unanswered questions, if you go back to that deliberation room and you were wondering what was really the speed limit when the crash happened, where the crash happened, they owe you an answer to that. They owe you that answer. Proper lookout is another manner of means. Now, there was a visibility issue. We heard that from Joshua Rodriguez. Joshua Rodriguez was the one where he had his wife call 911. He was the only person that kind of saw the accident happen. He was the only person that was behind. And he says that he saw Alex speed up in front of him and he heard the crash. He's an unbiased witness. He has no motive here. He's not coming from the government. What did he tell us? He said he could not even see what happened. Why? Because he could only see the roofs of the cars from his vantage point. That's all he could see. He could not see the police vehicle. He testified to that. And why is that? Well, he explained to us the highway, it curves, it goes up, and then it goes down. It's not straight and flat like the police want us to believe. Because this witness who was there that day behind the crash, he said that. He explained it to us. And if Joshua couldn't see what happened with the crash, then Alex couldn't see. He could not see that there was an accident in front of him. Leslie Salazar, she explained the chaos of the scene that night. She explained that there were cars that were reversing to try to get off the highway. They were impatient. They didn't want to stay there anymore. She called 911. And she told us she called 911 so they would know where to go because of the chaos of everything. Avoiding colliding with another vehicle, failing to brake, and proper following distance. Those are other manners and means. What we heard from Detective Doyle is that there was no evidence of braking. There was no evidence of swerving. There was no evidence of evasive action. What does that mean? What does that mean if somebody doesn't brake, swerve, take any sort of evasive action when they're going towards an accident scene, when they're going towards standstill traffic? It means they're not aware. It means they're not aware unless they want to kill someone else and kill themselves. And there's been no evidence that he was actually aware of it. Detective Doyle says, well, if somebody doesn't brake, doesn't take evasive action, doesn't do all those things, it could be one reason is that they're not paying attention. And if they're not paying attention, then that means they're not aware. They're doing something else. We know that no one who is aware of that risk would do such a thing. No one. It doesn't make any sense. You have to use your common sense and know that there's no way that Alex could have been aware, because he would have done something to prevent that. Now, the question is, should he have been aware? He should have been aware. Of course he should have. Paul Martinez, he told us he didn't see police. He just saw lights. He saw cars turning around going the opposite way. He saw cars going wrong way. There's about 5 or 7 of them that just kept going off of the highway, both sides. He's in his lane. He told us there's cars coming this way, one way, and there's cars coming this way as well. I saw it. That caused all of this. That all came together. And he himself told us he believed the accident was because of the wrong way drivers. He believed that, and he was there that night. Peter, he saw wrong way drivers as well. He saw Alex go in the air. And he also said something very important. Peter said there was a white car behind me. There was a white car behind me. Where is that white car? That means that there was a car in between Peter and Miss Saybert's vehicle. We don't know where that car is. We don't know if that's one of the cars that went the wrong way right before this accident happened. We just don't know. And that's a serious question. He said he probably turned around. This is not an intoxication manslaughter case. It's not. It wasn't charged as an intoxication manslaughter case. And we're asking you not to let the state make you believe or think that it's an intoxication manslaughter case, because there's been no evidence about that. There was so many officers on the scene, so many, and they could have brought you any one of them to say anything about this, and they didn't. None of the officers saw any signs. There was no signs of impairment. The only evidence that they have, and they have presented to you, was from Alex himself when he cooperated. And what Alex told the police is that I had 4 to 5 beers about 8 hours before this, around 6 p.m. when I was golfing. That's what he said. No witness testified to any signs. Their own experts said that he was not intoxicated. Officer Morgan, we asked him, he was the first officer, any signs of intoxication on Castro? No. There's 10 post-op clues. Did you notice anything? Slurred speech, wobbly, unsteady on feet? No, he did not. Detective Orta, their expert, he said Alex was not intoxicated. He's a specialist. He's trained to recognize certain clues. He performed the HGN on Alex, we know that. And he says that he saw 2 clues, but that wasn't enough, that he was not intoxicated. SAPD Detective Martinez. Detective Martinez, she told y'all that she smelled alcohol until Gary showed her video and reminded her that when she was there on scene that night, right then and there, she told her supervisor when he asked her, "Did you smell anything on Alex?" She said no. Of course she wants to say yes after the fact. Of course she wants to hold somebody responsible for what happened. That's understandable. But that night, she said no, she did not smell anything. She knew that the primary crash was Shayna Lassell. She told us that Officer Morgan should have called them to let them know that there was a wrong way driver, but they didn't. We know that Alex consented to search his vehicle. He did that. After hours and hours and hours of being there, he told Detective Martinez asked him, "Can I search your vehicle? Can I get the airbags? Can I see how fast you were going?" And he says yes. Even hours and hours of being held there, hours of being questioned, hours of knowing that he could not leave, that he was being detained, he still consented to that. This case is about an accident, a horrible accident. We heard that from the medical examiner who listed the manner of death in this case as an accident. Deadly weapon. Not true. It's not true that Alex intended to use his car as a deadly weapon. And we know that because he was not aware. This is not a case where somebody's just shooting in the middle of fireworks going on in the city. where other people are around. Then of course you should be aware that there's people around you.
5
and
minutes.
Thank you, Judge. What comes up has to come down. You're aware of that. That's not this case here. He was not aware that this could happen. This is not a case where he was throwing a rock off the highway and he could have been aware that he would have killed somebody. He did not intend to use his vehicle to kill anybody because he was not even aware that somebody was there. When you go back there, hold the state to their burden. Hold them to proving beyond a reasonable doubt that Alex knew of Miss Sabert's car in front of him and continued to go 91 anyways. Continued knowing he would kill himself. And what that means beyond a reasonable doubt is that if you go back there and you think perhaps he knew, maybe he knew, maybe you should have seen it, maybe, that's not guilty. If you go back there and you think it's probably likely that he knew and he did it anyways, that's not guilty. The burden is beyond a reasonable doubt because they have to prove to you that he was actually aware of it and continued to do it anyways. Officer Lechuga, the state, when they presented this, they just wanted to go on to this accident. They did not mention anything new about the first one and the details of that. We had to bring the other officer this morning that you heard from today, Officer Lechuga, and we brought her to testify about Shayna Lassell. And she told us Shayna Lassell went the wrong way, caused his accident, and I wrote her a ticket and dropped her off with her husband. That's it. That's how this story ends. But for Shayna Lassell causing that horrific accident, Miss Sabert wouldn't have been standing in standstill traffic. She wouldn't have. She might have already been home. And but for the police not warning other drivers, not putting up flares, Alex would have been aware of what happened. He would have been aware that there was standstill traffic in front of him, but he wasn't. All their evidence points to is that he should have been aware. That's it. Not that he actually was, because it doesn't make sense for someone to do that. And we're asking that you find him not guilty of manslaughter because he was not aware of what happened. He could not have been aware that there was standstill traffic, and he would have not continued to drive at 91 miles per hour knowing that there was a car in front of him. He would have not done that. We ask that you find him not guilty of manslaughter. And if you want to hold him criminally responsible for this, the only thing that the state has provided some evidence of is criminally negligent homicide. That's it. That he should have been aware. He should have been aware of what he was doing. But it's important to remember he was going 91 miles per hour on the highway at night when there's not usually a lot of cars. He wasn't going the wrong way. He wasn't in a residential area. It wasn't like that.
State.
We bear a heavy responsibility when we get behind the wheels of our cars. Each and every single one of us is aware of the fact that if we are irresponsible or if we are reckless or any of those things, that we can kill someone. That risk is inherent in driving a car. The defendant's actions were reckless that night. He knew exactly what the risk was of not hitting the brakes, of driving over 90 miles an hour, of not taking evasive action, of firing a missile into a crowd of people. You've heard evidence from almost every single witness who was there at that scene. They all said that they saw this traffic. You heard from Leslie. She had more than enough time to see the traffic and to take an earlier exit to avoid it. The witnesses who were stuck in the traffic, they all clearly saw that there was a traffic buildup. The brake lights you could see for miles. Even the victim knew that there was traffic. All of them stopped. No one else died that night except for Alexander Seibert. No one else killed someone except for Alexander Castro. What was the very first thing he said when he got out of that car? I saw brake lights and I tried to brake. He knew what he was supposed to do in that situation, and he failed to do it. He never once changed his story up at least the first 2 or 3 times he told this Officer Morgan about saying, well, I didn't brake or I didn't see it. Each and every single time was, I saw brake lights. We all agreed in voir dire, that's the universal sign of there's traffic, there's cars on the road. You need to slow down. But he didn't do it. And he tried to lie about it. There's no roadway evidence that he ever once touched those brakes. There's no roadway evidence that he ever once tried to turn the wheel. There is evidence that to the left of this traffic, there was a lane wide open for him to go into. And he could have slowed down at that point, but he decided not to. The defense has been arguing and saying, well, it would have to be suicidal in order for him to do something like that. Well, guess what happens when you do something that's so suicidal and you involve another person? Guess what? You're being reckless with the risk to that other person. The speed, 91 miles per hour, over 90. Confirmed by both the black box data and the math. Confirmed by what he did to those other cars. You saw that in person yourself. That's what 91 miles per hour into the back of a car does to the other car. It destroys it. It obliterates it. That, of course, is a deadly weapon in the manner of its use. Driving a car 91 miles into the back of someone else is using a deadly weapon against that person. His actions were reckless. He never once took any of the responsibility that night. I tried to hit the brake. I gave it all I got. You guys can't blame me. But then he took that extra step. He knew that the victim was injured. He told Officer Morgan, they told me about how she's doing. Once he knew about that, he changed his story to now she came into me. None of the evidence supports that. She was at almost a dead stop going to the right. He knew that she wasn't going to make it. And so there's that blip of someone else I could point the finger to and say it was them. At no point did he ever once say that there was that other cause other than her. He's blaming a little dead girl for his own actions. Because he knows what he was supposed to do. I hit the brakes and gave it all I got. Well, turns out he didn't. I tried to stop. I tried to avoid him. Didn't really do that either. Only one person that night killed someone else out on 281. Miss Lassel didn't put her foot on the pedal of that truck. SAPD wasn't behind the wheel. And she used to not evade. It's just him. Everyone would have been okay if not for his actions. The victim was still alive despite sitting in traffic. The accident had already happened and she was still alive. SAPD hadn't shut down that highway, and yet she was still alive. But it's when she crossed paths with him that she died. He's the cause of her death. Defense is bringing up criminally negligent homicide. That's what's called a lesser included offense. Less punishment.
Objection, Your Honor. That is improper argument.
Sustained.
Your Honor, we move for an instruction disregard.
All right, ladies and gentlemen, you're just to disregard counsel's last statement.
Your Honor, we move for mistrial.
Denied.
criminally negligent homicide that he should have known. He knew. He knew exactly what he was doing and what his actions would cause. Do not hesitate for a second there. Everything has been to blame everyone but himself. It's SAPD, Miss Alassel, it's Miss Siebert, but not him. SAPD messed up their investigation. There are several things that Officer Morgan stated that he could have done, and he didn't. That's a lucky break for the defendant. He got the benefit of that. There were no direct witnesses who immediately came forward and said, this is what I saw. It's another lucky break. That's another benefit. At this point in time, the lucky breaks need to stop. There needs to be accountability here. There needs to be someone, again, jury of his peers who come in and say, enough is enough. To hold him accountable. To make sure that it is clear that this is not okay in our community. By saying not guilty or criminally negligent homicide, it's as if you're being asked to say, well, as long as SAPD doesn't set up flares, and as long as someone else causes that traffic buildup, slam into the back of someone going 90 miles per hour, that it's okay. Obviously, all of you know it's not. Because of the devastation it can cause to not just yourself, but the other people on that roadway. This was Alexander Siebert. She had just graduated from UTSA. Her life was only just about to start beginning. This is what the defendant did to her. This is what he caused by his actions. Doesn't even look like a car anymore. The conscious disregard, safety of everyone else on that roadway. There's no evidence that he was sleepy. There's no evidence that he was distracted. There's no real evidence of anything other than the fact that his eyes were on that roadway. The state is asking you to find him guilty of manslaughter because that's what this is. It is the reckless disregard of the unjustifiable risk. The fact that someone would be willing to do this again, it's just shocking. The state is asking that you find the defendant guilty of manslaughter. The state is asking that you find the deadly weapon allegation true. Because any vehicle going that fast, going into someone, deadly weapon, plain and simple. Anyone who says that they saw the brake lights and took no evasive action or no attempt to evade knew what they were doing. There's no highway in Texas that allows you to go up to 90 miles per hour.
Objection, Your Honor. Facts not in evidence.
Ladies and gentlemen, you'll remember that evidence as you received it.
Your Honor, may I get a ruling?
Yes, overruled. You'll remember the evidence as you received it.
The state is asking you to find him guilty of manslaughter.
All right, court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Can I have parties announced for the record for the state?
Daniel Escobar, Jason Gary with the state.
Defense?
Jasmine O'Brien and Jason Goss for Mr. Castro.
And are you Mr. Castro?
I
All right, the court has been informed by the deputy that a verdict has been reached. She's going to line the jurors up and we will bring the jury in. Record. All right, so the court realizes that in cases as these, and probably any criminal cases, emotions can run high. There's not to be any outbursts. There are not to be any exclamations. If they are, then you may be excused from the courtroom. And if your testimony is needed, you may not be allowed to testify. Does everyone understand? All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you'll hand the verdict form to Deputy Laura, please. All right, if defendant, please rise. All right, with regards to the charge of manslaughter, it says we find the defendant not guilty. With regards to the charge of criminally negligent homicide, says we find the defendant guilty. With regards to the use or exhibited use of a deadly weapon, it says we so find that a deadly weapon was used or exhibited, namely a motor vehicle. Does anyone wish to have the jurors polled?
No, Judge.
All right, ladies and gentlemen, I'm gonna have you wait in the jury room, and then we'll call you back in a moment.
All rise for jury.